Good afternoon. Welcome to the fifth installation of the Alliance Defending Freedom American Culture on Appeal Symposia Series, Cakes, Unions, Pregnancy Centers, and Travel Bans, the 2017 Supreme Court terms indelible impact on freedom. Alliance Defending Freedom is the largest religious freedom nonprofit law firm in the world and advocates for the right of everyone to freely live out their faith. This series of symposia brings together advocates, scholars, and experts to engage in civil discourse on some of the most challenging and at times divisive issues of our day. The first panel of this Constitution Day event will feature a review of free speech and religious liberty implications of the Supreme Court decisions of the 2017 term. In Masterpiece Cake Shop v. Colorado Civil Rights Commission, cake artist Jack Phillips declined to create a custom cake celebrating a same-sex wedding because doing so would violate his deeply held religious beliefs. The Colorado Civil Rights Commission ordered Mr. Phillips to create cakes for same-sex weddings if we were to continue designing wedding cakes and to provide the commission with an explanation of all work declined. The court held that the commission's action in assessing Mr. Phillips' reasons for declining to create the cake violated the Free Exercise Clause. In National Institute of Family and Life Advocates v. Becerra, California's Reproductive Fact Act, AB 775, required pro-life pregnancy centers that are licensed medical centers to post a disclosure saying that California provides free or low-cost abortions and contraceptive services. The law also forced unlicensed pregnancy centers to add large disclosures about their non-medical status in all advertisements, even if they provide no medical services. The court held that NIFLA was likely to succeed in its claim that the California law violates the First Amendment. And Janus v. American Federation of State, County, and Municipal Employees concerns the power of labor unions to collect fees from non-union members. Under the Taft-Hartley Act of 1947, union security agreements were allowed by state law. The Supreme Court ruled that such union fees in the public sector violate the First Amendment, overturning a Boud v. Detroit Board of Education that allowed such fees. Now, throughout the panel discussion today, we invite you to join the discussion by using hashtag SCOTUS and tweeting at Alliance Defends. We're going to have time at the end of each panel, maybe 10 minutes or so, for any questions that you might have with the panelists, so feel free to ask. We'll have a microphone circulating the room at that time. Now, participating in our first panel will be John Bursch, Vice President of Appellate Advocacy for Alliance Defending Freedom, Amanda Shanner, Professor at Penn Law School, and Scott Keller, Solicitor General of Texas. And Mr. Bursch has represented Fortune 500 companies, foreign and domestic governments, top public officials, and industry associations in high-profile cases, primarily on appeal. He recently argued and won Lee v. United States at the U.S. Supreme Court, his 11th successful outcome at the court since 2011. Ms. Shanner is a PhD in law candidate at Yale whose research focuses on constitutional and administrative law, speech and association, and their intersection with behavioral sciences. A graduate of Yale Law School and Yale College, Ms. Shanner served as a law clerk to the Honorable Cornelia Pillard and the Honorable Judith Rogers of the D.C. Circuit. She has a background in constitutional litigation and social movement strategy. And Mr. Keller, before becoming Solicitor General of Texas, served as chief counsel for Senator Ted Cruz and was attorney at Yoder Coleman in Austin. He clerked for Supreme Court Justice Anthony Kennedy, was a Bristow Fellow at the Office of Solicitor General of the Department of Justice, and clerked for Chief Judge Alex Kozinski of the U.S. Court of Appeals for the Ninth Circuit. Now, our moderator for the first panel is Supreme Court correspondent Greg Stohr. Mr. Stohr has been Bloomberg News Supreme Court reporter since 1998. He's a former judicial clerk and congressional and campaign press secretary. He graduated with honors from Harvard Law School in 1995. Will you please join me in welcoming Greg and the panelists?
Thanks, Bob, and thanks for having me here to moderate this panel. We're going to start off by talking about the Masterpiece case and probably spending the bulk of our time talking about that. And I think my job is generally to say relatively little and let these very smart people discuss the case, but I'm going to take 15 seconds or so to invoke moderator's privilege and just explain how I, as a reporter, saw this case, which was when the court took it, it seemed like this tremendous titanic battle between two sets of rights, equality on one side, speech and religious rights on the other side, and you ended up with a rather anticlimactic opinion, at least in terms of what it said about other cases. But within that opinion were some provocative and debatable comments made by both sides. So I'm hoping that our panel will discuss both the narrow confines of the opinion, the pros and cons of it, and those broader questions that the court didn't get to, and maybe look forward to what might happen next with this, with this issue. So with that, I'm going to turn it over to the panelists to make opening statements, starting with John, who I think will probably give us a little more of a framework about what the case was about.
Sure. For the two of you in the United States who aren't familiar with the facts of Masterpiece Cake Shop, it involved Jack Phillips, a master cake artist, who, if you've seen any of the cable TV shows where they have these amazing cakes that they make, he's one of those guys. And Jack would serve all of his customers, but he wouldn't make every message that somebody requested. So, for example, if someone asked him for a cake that was disparaging towards someone, anyone, he would refuse to make that cake. He refused to make cakes with alcohol because he was concerned about the implications that would have for people who had alcohol addictions. He also refused to make Halloween cakes, which apparently is a very lucrative part of the cake business because of its association with the occult and things like that. And so those beliefs that he had as he created in his artistic capacity came to a head when two gentlemen and one of their mothers came into the cake shop and asked him to create a custom cake for their wedding. Now, one factual point to get really clear, because the media sometimes spins cases in a way that doesn't accurately reflect what happened. When that couple first came into the shop, Mr. Phillips offered to sell them anything that he had in the shop, cookies, brownies, even cakes in the cooler. The one thing that he said he couldn't do was to custom design and create a cake for them, because that would violate his deeply held religious beliefs. So some of the media reports that said this case's outcome would mean that a 911 respondent could refuse to help someone because of their sexual orientation, or that the fire department could let someone's house burn down because of that person's sexual orientation. All that is completely false. That didn't have anything to do with this case. And what the Supreme Court, in its majority opinion, did do is it affirmed generally applicable civil rights laws that ensure that people are not discriminated against because of their sexual orientation. Mr. Phillips didn't have any beef with that at all. But the question then came down to this very specific situation. He was being asked to use his artistic talents to make something for a ceremony that he considered to have religious, almost sacramental significance. And could the government force him to do that? And as Greg mentioned, some of the big questions in the case with respect to speech went unanswered, and there'll be further cases that we talk about in the next hour that may have the ability to end up having those addressed. But specifically, they honed in on the free exercise component of his case. There had been a couple of commissioners who had expressed on the record in public comments outright hostility towards Mr. Phillips and his religious beliefs. In addition, the court cited evidence that there were other cake bakers in the state of Colorado who had been asked to create cakes that had anti-same-sex messages on them and had refused to do that. And the court looked at that and said, well, that's not fair because you're treating different people differently. And that is because of religious animus. And so the court, in what some commentators have described as a very narrow ruling, said you have to treat someone who's religious the same as someone who's non-religious when you're going through one of these public government proceedings, because Mr. Phillips and Masterpiece Cake Shop did not get that neutral treatment, then they prevail and the complaint has to be rejected. But what's important to understand about the court's comments on that religious animus is how broad they really were, because the court said anything, even a slight suspicion that a governmental process was tainted with religious animus is enough to throw out the governmental process. And so, here, obviously, there was blatant discrimination on the record. But that doesn't mean in the future that if, for example, Colorado civil rights commissioners keep their religious animus only in their heads and they don't say it on the public record, that that's going to be enough. Because even the tiniest suspicion that something may have been motivated because of someone's religion is going to be enough to kick the case. Now, one of the interesting things that I hope we can discuss in some detail this morning is kind of the aftermath of the Masterpiece Cake Shop. What has been reported, but not widely, is that from the date that the Supreme Court granted the cert petition in Masterpiece Cake Shop up through the date that the opinion came out, Mr. Phillips continued to be bombarded with intentional requests to make cakes, design cakes that people just knew were going to violate his religious beliefs. He was asked to make a cake as a celebration for Satan's birthday. He was asked to make one with a pentagram symbol on it. He was asked to make one of a 3D sculpture of Satan with a sexual object, which I'm not even going to describe. He was also asked to make a transgender coming out cake that was one color on the outside and a different color on the inside. Each one of these, the asker knowing that Mr. Phillips was going to have to say no to all of these, and each one predictably then being referred to the Colorado Civil Rights Commission for further action. As it turns out, only 24 days after the U.S. Supreme Court issued its opinion in Masterpiece Cake Shop, the Colorado Civil Rights Commission was right back at it again, and they had filed charges against Mr. Phillips, or at least scheduled hearings with respect to the transgender coming out cake. And so now, after going through years of this litigation battle and finally getting the government off of his back and not being forced to create cakes contrary to his deeply held religious beliefs, he's back in it all over again. And so ADF, on behalf of Mr. Phillips, is not only helping him defend that action, but has also filed affirmatively an action in Colorado federal court saying that these persistent intentional violations of his religious free exercise rights and other constitutional rights need to be stopped right at the courthouse gate so that he doesn't continue to be persecuted. But going back to the opinion itself, for me, the big takeaway really in Justice Kennedy's opinion is pluralism. I think Justice Kennedy was really clear in sending a message to both sides of this public debate that Greg alluded to at the very beginning. You know, on the one hand, proprietors of businesses need to be very clear that they have to honor these civil rights laws and not discriminate anyone because of who they are, whether it's their race, their sex, their orientation, their ethnicity, their religion, anything. They have to act neutrally. But at the same time, government officials need to acknowledge that people with deeply held religious beliefs are allowed to practice those beliefs in the public square. And when those beliefs are being denied the right to be practiced solely because of religious animus, the government is going to be stopped from doing that. And so I really see it as can't everybody just get along in the aftermath of a Obergefell opinion? And that's a message that I think everyone can take to heart.
Amanda, you want to tell us why he's all wrong?
No, I agree with actually many things that he said. So I'm Amanda. Hi. It's so wonderful to be with all of you today in this beautiful space. Two clarifications. One, my appointment is the Wharton School at UPenn, but also I should clarify that I spent the last year at the American Civil Liberties Union, where I worked on their Supreme Court docket, including I had the honor to represent the gay couple in Masterpiece Cake Shop. So that's part of why I'm here. So I want to say in my brief introductory remarks two main things. One, about the stakes of Masterpiece Cake Shop, and two, to raise some questions about why the opinion came out in the very narrow way that it did, that I think potentially bears upon future cases in this vein, and also sort of like the future of the Supreme Court's First Amendment docket. So first, the stakes of Masterpiece. As you all may reasonably think, as I did before I worked on the case, I thought that Masterpiece maybe was about cakes and gay people, and potentially about whether or not cakes are art. And as I dug more into the case, and I think as the Supreme Court dug more into the case, they realized what was at stake was far maybe not more important, but deeper and broader principles. So let me explain. For centuries, public accommodations laws have protected the rights of persons in goods to obtain goods and services on equal terms. They've protected the equal opportunity to participate in what the Supreme Court has called the transactions and endeavors that constitute ordinary civic life in our society. And over many decades, both the Supreme Court and Congress have rejected requests for constitutional exceptions from public accommodations laws. Those have come under many different constitutional principles, and as an academic, I think that that's really fascinating, but the court and Congress have rejected those. So for instance, in Heart of Atlanta Motel, the court rejected a request under principles of substantive due process by a motel owner to refuse to serve black customers. In a case called Piggy Park, the court rejected as frivolous a religious-based claim brought by the owner of a barbecue restaurant who didn't want to serve black customers on the grounds that his religion required strict separation of the races. And in a case called Hishon v. King and Spalding against a large law firm, the court concluded that rejected a freedom of association claim that the partners made that they would have an association right not to make a woman partner. In all of these cases, the court has rejected the principle that you have an unlimited right to decide who you choose to engage with in the basic economic endeavors of our society. And instead, it's held that discriminatory conduct by business entities has never been accorded affirmative constitutional protections. Masterpiece is really interesting because it raised that same basic question again of, do I have a right not to engage with someone in ordinary economic life? And the prevailing wisdom was that the court took the case to revise its long-standing precedent, and most likely, most people thought, to cut open a pretty big First Amendment free speech exception to public accommodations laws. But to the surprise of many, it refused to do so. It declined to do so. The court instead decided, as Scott said, decided the case on perhaps the narrowest grounds under the established principle that a government violates free exercise principles if it enforces a facially neutral law in a biased way that targets religious beliefs. But the court declined to accept either of the bakery's two principal arguments, either under the free speech clause or the free exercise clause. That was actually a tremendous win for civil rights because it left in place the constitutional principles that have been at play for now many decades. It preserved the decision of the court like I said, for decades to deny claims to constitutional right to discriminate and uphold public accommodation laws that require equal treatment. It also left in place all public accommodations laws. It left in place let me say that again. It left in place all public accommodation laws, including Colorado's. So it didn't strike down the law. But the majority went further to reaffirm the longstanding principles that businesses open to the public have no constitutional right to discriminate, saying that while religious and philosophical objections to gay marriage are protected, it's a general rule that such objections don't allow business owners and other actors in the economy and in society to deny protected persons equal access to goods and services under a neutral and generally applicable public accommodations law. The court recognized the fundamental principle that the case wasn't about access to cakes, but instead about larger societal harms at play when businesses open to the public deny certain people products that they would offer to everyone else. And the court explicitly rejected the, I think, really unprecedented suggestion of the Solicitor General's office that only laws protecting against race discrimination, so not, say, discrimination based on sexual orientation or people with disabilities, may withstand First Amendment challenge. So the opinion was strikingly narrow and unexpected in that sense. But more than that, only Justice Thomas and Justice Gorsuch endorsed a free speech principles that would protect the right of any bakery to deny service to a gay couple on constitutional grounds. So I think that that's not at all what people expected. I think, frankly, either of us, what we expected to come from the court, right? Which brings me to a question about why the court decided the case the way that it did. I think when I came to the argument, one thing that I noticed through the middle of it is Justice Kennedy leaned back in his chair and he put his hand on his head, right? Like, oy vey, why have we taken this?
It's usually Justice Breyer.
It is, but it was Justice Kennedy. And I think one thing that became really apparent through the course of the argument was that there was a hard limiting principles question at play in Masterpiece, right? For example, if this bakery prevailed, could another refuse to sell a cake for an interracial or interfaith marriage on religious grounds to a divorced person remarrying? What about a florist or a caterer or an architect? And the speech claim wasn't that Mr. Phillips wasn't limited by its religious reasons. So thus at core, Masterpiece, and we disagree a little bit about how to characterize the facts in this case, unsurprisingly, but so apart from whether or not Mr. Phillips would sell a cake that he already had sitting out, it was established that he wouldn't sell the same cake to a gay couple that he would sell to a straight couple. So imagine identical cake, he would not sell that to a gay couple because it was being used in a gay marriage, okay? And in that sense, the case teed up a sort of much more basic question about what do I express when I sell something to you? Very similar to the question, I'm from Atlanta in the South, about whether or not in the 60s, if I sell a sandwich to a black person, does that express something about the status of African Americans in our society, right? It meant, I think, ultimately that the court felt like there was a whole handful of limiting principles questions that made this case much more difficult to provide a clean win for Mr. Phillips than I think the court anticipated when it began. And ultimately, the court ended up, I think, just declining to decide a bunch of questions, but again, reaffirming the basic principle that's been at play for many decades, that businesses open to the public can't deny service based upon who someone is.
Scott, you want to tell us why Amanda's all wrong?
Yeah.
Oh, no, I mean, no one's got it all right, no one's got it all wrong. First of all, I definitely want to thank Alliance Defending Freedom and Jones Day for hosting this event today. As the former Solicitor General of Texas, I was counsel of record on amicus briefs in the Masterpiece Cake Shop case, the NIFLA case, and the travel ban case. As an amicus getting involved in this case, you don't know exactly where the case is headed. And as you've seen from the discussion today, in Masterpiece Cake Shop, I mean, there were two related but distinct claims. There was the free exercise religion claim, and then there was the free speech claim. And in short, the free exercise claim kind of had two parts to it. One was a broader claim that an individual should be able to not provide services regarding a same-sex wedding on religious grounds, religious objections. And the second, the narrower claim, is the one that the court adopted, which was on these particular facts, the Colorado agency showed such an animus towards religion that itself showed that there was a free exercise violation. So even when you say it was a narrow holding, it was the narrower version of the free exercise claim, and the court didn't reach the free speech claim. In a lot of ways, I think you're right. The free speech claim would have been the claim that potentially could have had a much broader effect. But at the same time, that issue is open. And as we think about what the court is going to be faced with in the future, Masterpiece Cake Shop, of course, itself now has additional proceedings and could easily work its way back up through the system. But also there was another case, Arlene's Flowers, which was a florist in the state of Washington that had also been compelled by the state government to participate as a floral designer in making floral arrangements for a same-sex wedding. And so these types of cases I don't think are going away, and I think the Supreme Court is going to confront the issue at some point. But for now, what we know from Masterpiece Cake Shop is, first of all, by the way, this was not a 5-4 decision. This was not, in that sense, I think this is another example of the Roberts Court seeking some amount of consensus and truly not wanting to politicize the courts. And I think that's why you see a pretty narrow ruling on grounds that multiple justices beyond just a 5-justice majority could agree to. And at the same time, these are big issues hanging out there, particularly the free speech issues. And you're right. I mean, the fact of the matter is this is going to have repercussions and consequences beyond just same-sex wedding fact patterns. I mean, in some ways, I think what you're seeing in this case is the reason why it's so difficult is you have these principles of equality and public accommodations and tolerance. And tolerance can go both ways, but you have those principles. And then you also have this countervailing interest, which has been ingrained in American law for decades, which is we protect the freedom of speech. And by speech, at least as the U.S. Supreme Court has understood that term for decades, speech includes obviously much more than just what you say. And so, in some ways, what I thought the case may turn into is going to be a line drawing issue about, well, what counts as free speech? What counts as expression? I'd suggest to you that if what gives you a little trouble in this case is it's about cakes, and you're just not sure, is a cake expression? We can have that debate. But if we're having that debate, I think we're going to start to see very quickly that there are going to be aspects of providing services for any type of wedding that I think most people are going to say are core expression to be protected by the First Amendment. And if we are going to, as a society and governments, be in the business of starting to compel it government threats and penalties, and here, I mean, the Colorado agency had ordered Jack Phillips to essentially re-educate his family about these issues. I mean, this is a heavy sanction. If we're going to go down that road, I think the only way you can get there is if the U.S. Supreme Court were to retrench massively on all sorts of free speech precedents that it's had from the past few decades. And so I do think that those were the stakes. Now, those were the stakes that were avoided for the time being, but I do think the court is going to reach these issues as more of these cases continue to come up through the pipeline.
So there's a lot to unpack there. We probably have another 10 minutes or so to talk about the case, so let's see if we can work through some of that quickly. Amanda, one thing I wanted to ask you was, John portrayed this as being I called it narrow. John was portraying this as really, really important. He said even the tiniest suspicion of religious animus in a process like this is now going to be grounds for somebody to set aside the ruling of some government body. Do you agree with him in that characterization? Because, I mean, in truth, one can make a case that there wasn't a whole lot of evidence of religious animus. It was one, maybe two commissioners, saying some things in a multi-level process. Yes, there was a differential treatment with somebody else who wanted a different type of cake. If that's enough to set aside an order against Jack Phillips, isn't there going to be?
I don't think so. I think that that's a very generous reading of the case. I think that the concurrence written by Justice Kagan suggests that there isn't votes on the court for, with Justice Kennedy, there wasn't votes on the court for something that aggressive. We could ask whether or not that would change, but I don't think so. I also think that the travel ban ruling, which we'll talk about a little later, suggests that a strict read, as Scott had, is not accurate, at least in all contexts. Can I respond really quickly to one thing? Okay, which is to say this. So I teach and practice First Amendment law, and one thing that's important to know is that the First Amendment doesn't extend strict scrutiny to all areas of life. If it did, because everything we do could be understood to be expressive in some way, like my haircut or why you cut into traffic or whatever, we would have a very different way of organizing our society than we do. And one basic principle of First Amendment case law, which was at stake in this case, is when the government regulates conduct, regardless of what it expresses, so a neutral law, as long as it doesn't regulate because of what it expresses, that comports with the First Amendment under a lesser standard than strict scrutiny. And so I don't think it's the case that this case necessarily ultimately put that into play. As the way that I think that you suggested.
If I could just respond briefly to that. The words slight and suspicion are right in the majority opinion. They garnered the court's majority. Justice Kagan, in her dissent, obviously disagreed about what might constitute evidence of that slight suspicion, and so she kind of relegated to the sideline this differential between how different bakers turning down different types of messages should be treated. But her opinion only garnered 2 votes on the court, and the slight suspicion language isn't something that Justice Kennedy just created out of whole cloth. It comes right out of the Lukumi case. So I think the standard is high. The other one note that I want to make on Amanda's opening statement is about this idea that if you make a cake for one person, then you have to make it for everybody. And this was something that was discussed at length at the oral argument, and that was the ACLU's bright line position. But it quickly falls apart, because if you have a baker who makes a First Communion cake for someone with a cross on it, then that means they also have to provide it to the Ku Klux Klan, where they could burn the cross off the cake at a ceremony. Or if Byron White was having a retirement party, and the cake that he requested was, white is great, well, you'd also have to sell that same cake to David Duke. Everybody realizes that just because you make a cake in one context doesn't mean it means the same thing when it's in another context. And so that's not a test that's going to be able to be used by anybody as a bright line rule in these types of cases.
Scott, what do we do about all the line drawing problems? If the court gets into the speech questions, as you were talking about, how in the world do you draw those lines that Justice Kagan was really going after in the argument, where she says, well, how about the makeup artist? Is that person expressing? Should that person be exempt from having to take part in, do somebody's makeup for same-sex wedding? She had a long list of hypotheticals like that. How can you possibly come up with a satisfactory answer to that?
Well, so the first answer about this is I would say that that's not even necessarily an issue about just weddings or same-sex weddings. I mean, in some ways, the circuit courts for decades have been grappling with what counts as something that is protected speech. You know, is a symphony protected speech? Is a photograph? Is written calligraphy? You know, if we're not just talking about verbal communication, what counts? And that issue is just a core First Amendment free speech clause issue. And so in some ways, I think, you know, there are different tests that have been proposed. The circuits have worked through a few. But some of that is also just the nature of constitutional adjudication with a particular case or controversy before you, that you start to ascribe what are the attributes of what should be protected as expression. But I think where you could start to draw the line is, and what the court has said, is if this is a true attempt at artistic creation, that should be protected expression. And the courts outside of at least this particular area have suggested that it shouldn't really be the court's business all that much to be asking, is this artist really trying to create art? If they subjectively are making a very sincere attempt at doing so, who's the court to say whether, you know, some of the postmodern atonal music, for instance, is that protected expression? Well, the courts have said yes. And the courts have largely said, even if you yourself cannot decipher a message from this, if this is a good faith, sincere attempt at art, that is protected by the free speech clause. And what that means, therefore, in this context, is that governments cannot use penalties to compel you to engage in that expression. And in some ways, with Masterpiece and NIFLA and Janus, all of those, in those senses, are compelled speech cases. And the Supreme Court held decades ago that governments cannot compel speech. And so that's why, yes, is there a line drawing issue? Yeah, and it may be tough in some cases. And perhaps a cake case is not the best fact pattern for the Supreme Court to address that issue, but maybe that's also why we saw a very narrow ruling in the Masterpiece Cake Shop case.
So I think this argument is totally orthogonal to what happened in Masterpiece. And let me say it in this way. So it's the difference between regulating what Rembrandt can paint and whether or not when he opens an art store, whether or not he can refuse to sell something to black people. Does that make sense? So it's like whether or not something that you will sell to everyone, you will not sell to this particular person because of what you think that expresses, right? I'll sell sandwiches to everyone, but I won't sell a sandwich to you because I don't believe that you should be in my shop or because I don't think you should use my cake in this way, right? So it's not a regulation of what Jack Phillips can make. He can make any cakes he wants to make. He just can't make, if he will make this cake for you and sell it to you, but the very same cake he won't make for me, that's a neutral regulation, again, of conduct, regardless of what's expressed, regardless of what type of cakes. If he doesn't want to make Halloween cakes, he doesn't have to make Halloween cakes. But if he'll make you a Halloween cake, then he has to make me a Halloween cake, right?
He will make you he won't make anyone a Halloween cake.
Yeah, that's what I'm saying.
But if he made a birthday cake for someone, he would make a birthday cake for you.
But if he made a wedding cake for you, he won't make a wedding cake for me.
I mean, that's why we reject the hypothetical of the Rembrandt churning away a black customer. And where you can really see this play out is with Baron Nell Stutzman and the Arlene's Flowers case that was mentioned. Because her customer, Rob, who was gay, she served faithfully for over 9 years. She made floral arrangements for any occasion that he wanted, including celebrating the birthday and the anniversaries of his partner. The one thing that she couldn't do was when he came in and asked her to participate by making floral arrangements for her wedding. That's not just turning him away because of his sexual orientation. It's saying that this is something that's religious and sacred to me, and I can't be a participant in that without violating my deeply held religious beliefs. That's very, very different than simply saying, if you're gay, then go away. You can't be in my shop. I mean, that was not her position. That was not Jack's position. It's not the position of any of the plaintiffs that you see in these numerous cases that are working their way through the judicial system right now.
Can I say just one short thing, which is that certainly that appears to be true of Mr. Phillips. I think one of the questions is, if we establish a principle based upon these facts, how will that translate? Because the First Amendment is a general principle for everybody, not just in this particular context of gays and cakes. And part of the law is how much we want the courts to investigate why this particular person is doing it and whether or not it's reasonable. So it may be that Mr. Phillips or Arlene's Flowers doesn't want to sell to gay people because they faithfully disagree with gay marriage, right? But what about another context that is very different from that and less widely held, right? And why wouldn't someone who's equally faithfully believing in a more minoritarian position, why wouldn't that be equally protected? Like, I am an Orthodox person who doesn't think that women should be buying things or out in public life, and so I don't want to sell something to you, or I don't want to sell you this particular thing because you're unmarried or what have you. There are a bunch of different things that are quite plausible that could occur, and so it's, I think as the court dug into it, it became less apparent how you could possibly limit a rule that was a generally applicable First Amendment rule only to gay people or only to weddings, and that was the challenge that the courts faced in Masterpiece.
We need to move on, and I'm hesitant to ask this question, so maybe I'll ask you each to answer this really quickly because I am quite curious. Going forward, after we have this opinion, is this going to be a matter of the free speech rights of the Jack Phillipses of the world or the religious rights of the Jack Phillipses of the world? Which part of the First Amendment is going to be doing the work?
A simple answer, I think it'll be both. I think there's a number of cases in the system where you have the same kind of anti-religious animus expressed by government officials, and when the case can be resolved on that narrow ground under Masterpiece, then that's the way that courts will resolve them. You know, I do think as we get into some of these core speech cases, talking now about videographers and calligraphers and printers and things like that no one could disagree that that's core speech. Eventually one of those cases will come up and we'll have a speech ruling as well.
I think it's a little hard to say at this point. I think part of it depends on who's going to be on the court. I think that the narrow rulings in both Masterpiece and NIFLA suggest that the court, at least as made up with Justice Kennedy, maybe have a little bit of less of a taste for the speech aspect of these sorts of cases and maybe more inclined towards the religion aspect. But I think it's really hard to say.
Yeah, I mean, I think as long as the courts can go near, they're going to continue to, because, I mean, these are charged fact patterns. I don't even mean that negatively. I just mean, you know, if you have a couple that wants to have a wedding and wants to celebrate their life together, and then they're being told that they can't buy a particular service or a cake or photography, like, yeah, that is going to have an effect on them. And I don't think that anybody up here is saying that the feelings and thoughts and what that couple is experiencing should be completely minimized and thrown out the window. I think what is happening, though, is there are countervailing interests. And I think this is why the Justice Kennedy, the pluralism, the tolerance in a diverse society principle is completely alive and well, and is going to remain to be seen how this plays out. Because you also have the countervailing concerns of, do we want governments to have this type of power about using government penalties to, and I know we disagree about this, but to compel expression. And I think we have to be very careful about the amount of power that governments are being given. And the U.S. Supreme Court for decades has been very protective of the ability to not only engage in speech, but also to be prevented from having speech compelled. And so I think this is why this is a really tough case, and I think going forward, the courts are going to try to continue to rule as narrowly as possible. I don't think they're trying to sweep as broadly as they can by any means.
Okay, I'm going to see if we can very briefly touch on a different case, which is the Trump travel ban. Everybody, I think, is very familiar with it. It, of course, also involved questions of religious animus. And, John, I want to ask you, you use that phrase, tiniest suspicion, in the context of religious animus by a member of, say, a civil rights commission. Why was what I think some people would say was a much greater than tiniest suspicion of religious animus on the part of the president not enough to invalidate his travel ban on Establishment Clause grounds?
I think that really turned on the uniqueness of the presidential position, and the court being able, at least a majority of justices, being able to draw a line in the sand between a candidate's statements on the campaign trail and an executive order signed with all the authority and office of the President of the United States, invoking a statute which specifically gave him the power to implement an order like this, and saying we're going to look at those as two separate things. I think because of the presidential authority aspect of this, it takes it entirely out of the realm of cases like Masterpiece, like Arlene's Flowers. Just one side note, if you think about the position that the dissent adopted in that case and the danger that could have, if a candidate on the campaign trail said, well, I think that we should bring more immigrants into the country because I think these minorities have been historically persecuted in foreign countries, that would be a reason to invalidate their executive order that opened the doors. So you've got to be really, really careful when you're talking about presidential authority, about what statements people make can be actually attributed to the president as an office.
Amanda, is he right, or is there a double
I
standard?
think both. I think that, no, both. I think if you look at this in an intellectually honest way, it's hard to read both cases and not to really have a big question mark about, is this the same standard? I think that the court articulated it in a way that might be cabinable to just sort of like external foreign power affairs. But I do think it's real hard to read all of the evidence piled up in the Muslim ban case in comparison to the level of animus displayed in Masterpiece, and really think that there isn't a very dramatic difference.
Scott, what's
I
your
think,
take?
I think one key difference between the two cases is in the travel ban case. Remember, this was travel ban, 3.0? This is the third time that the third iteration of this policy had been through cabinet secretary vetting and otherwise. And so you had this kind of attenuation between some of the comments made and the actual policy and when it was formulated. And that is different than the Masterpiece Cake Shop case. But I will tell you, having previously represented a state that faced some purpose-based challenges, the idea from the travel ban case of a presumption of good faith on behalf of legislators and government officials is something that is deeply rooted within the court's jurisprudence, and I think that is going to continue to be applied. And so then when you turn to the Masterpiece Cake Shop case, you don't see the words, the presumption of good faith, and I think part of the reason that may have been driving that is some of those comments were very blatantly anti-religion. So again,
Comparison to the Trump tweets.
Well, all this means, this remains to be seen. I think in both of these cases, you had two very unique fact patterns, and I think it might be hard to exactly create some kind of general principle from both of these that's going to solve a hypothetical fact pattern that we could come up with today.
Okay, let's jump over to the NIFLA case. I'll do a different order here. Start with you, Scott. Again, I think everybody's very familiar with the facts of the case, but just very briefly, the court invalidated two portions of a California law, one imposing disclosure requirements on crisis pregnancy centers that are licensed as medical facilities, and another set involving unlicensed centers that are not medical facilities. Scott, starting with the license portion. So the big argument was that in support of these laws one big argument was that they're just like informed consent requirements. We require those in the abortion context, that we let states require doctors to inform a patient that there are other options other than abortion. Isn't this just the same thing, only in reverse?
Yeah, and what the majority opinion said there are differences. And then the big difference is in an informed consent law that the court has upheld, certainly since Planned Parenthood versus Casey, is informed consent goes to you are providing a particular patient notice and information about a procedure that patient is about to have with a specific doctor at that same facility. And what the California law was talking about was compelling information to be told to people that they were not going to be having that procedure at that facility with that doctor. Rather, it was something along the lines of, California as a state has chosen to subsidize abortion or other means of certain policies. And so you had pregnancy centers that were saying, well, we don't want to have to give that information. The court said you couldn't conceive of that as an informed consent law because it wasn't providing informed consent, to get around like a negligence claim, for instance, that you didn't provide this patient with enough information. One thing I think is very unique, though, about the NIFLA case, particularly given the backdrop with Masterpiece Cake Shop happening at the same time, was my former boss, Justice Kennedy's separate concurrence. And so, first of all, if you'd grant me the ability to use my phone for this, I'd just love to read to you a passage of what Justice Kennedy wrote in his concurring opinion, which was joined by 3 other justices. What he said was, the California legislature included in its official history the congratulatory statement that the act was part of California's legacy of, quote, forward thinking, unquote. But it is not forward thinking to force individuals to be an instrument for fostering public adherence to an ideological point of view they find unacceptable. And by the way, I think the next line is probably the best encapsulation of Justice Kennedy's judicial philosophy in examining constitutional cases. He says, it is forward thinking to begin by reading the First Amendment as ratified in 1791, to understand the history of authoritarian government as the founders then knew it, To confirm that history since then shows how relentless authoritarian regimes are in their attempts to stifle free speech, and to carry those lessons onward as we seek to preserve and teach the necessity of freedom of speech for the generations to come. Now, the reason I think that is the best indication, or the shortest indication of Justice Kennedy's judicial philosophy, is it starts with textualism, it starts with history, but then it continues and is trying to apply history to current modern situations. But the reason I find that so fascinating, that we had that in an opinion almost about the same time as Masterpiece Cake Shop, is if Justice Kennedy had taken that exact language and put it into a Masterpiece Cake Shop decision, I think it might have been accepting of the free speech claim that Jack Phillips was raising.
Yeah, that's really interesting. So I think what was interesting about NIFLA actually to me is like what NIFLA wasn't, and how NIFLA is an interesting case, right? Because it's about a disclosure regime set up by the progressive state of California, brought by crisis pregnancy centers who are mostly faith-based and oppose abortion. Okay, the legal question teed up though could have addressed not just the abortion question, but also generally speaking, how should the First Amendment think about mandated disclosures? So like nutrition labels, or like, you know, alcohol is bad for pregnant women, or like you name it. And I think the case was interesting because it kind of brought together in some ways, actually in ways not unlike Masterpiece Cake Shop, the kind of like faith-based right and the libertarian right. And what's interesting is in NIFLA is the court really went more with the faith-based right? Like it saw the case more as a political speech case rather than as like a simple economic rights speech case. And so the opinion ended up being much narrower than what it was that I anticipated, and much sort of like more in line with the court's political speech cases, because I think the court viewed it like Justice Kennedy did, as sort of like an aggressive regulation of what's at core political speech. But that means the case didn't do as much kind of on the economic deregulation front than I think a lot of people had hoped or anticipated. I guess as a little bit of background, the First Amendment is, despite its real importance now, is actually its jurisprudence is quite young. You know, if the founding generations passed the Sedition Act, it was only until the early 1900s that there were any cases. There wasn't protection for sort of speech and economic life until the 70s. So the First Amendment has taken a pretty sharp libertarian turn in economic life. And NIFLA, to me, suggests maybe the court's uncomfortable with where that's going. There's limiting languages throughout that, I don't know, raises questions.
John, one argument that abortion rights groups were making about the California law was that these centers are misleading women, and these regulations, these disclosure requirements, are necessary to counteract that deception. Is that not a legitimate grounds for a state to act to protect and ensure full information for women who are at a vulnerable spot in their lives?
Hypothetically, it could be, but the majority rejected the proposition that that's what was actually happening. And the reason I wasn't surprised that this came out more like a true political speech case rather than an economic regulation case is because the legislative history made clear that this was all about politics. California, as many of you probably know, is very progressive on abortion rights. They've licensed physician assistants to perform abortions as well as doctors, so there's more of them available. They provide heavy state subsidization. They allow children to get abortions without their parents even being informed. So they're about as far out there as you can possibly be. They even describe themselves in the legislative history as being the gold standard for abortion rights in the country, but even that wasn't enough. They invited NARAL in to see what more they could do, and they decided to focus on these pro-life pregnancy resource centers, which were having a real impact in persuading women that what they were carrying was not just a clump of cells, but actually a human baby that should be protected. And so that was the ground that they had to go after. And so when viewed in that light, it's not surprising that the court viewed it as an anti-political speech case, because that's exactly what the legislative history showed it to be. And just to kind of put a fine point on what Scott was saying about the difference between the mandated disclosures here and those in Planned Parenthood versus Casey, in Casey, someone's going to get a medical procedure. Here, you're going to not get a medical procedure. And the majority didn't have any difficulty drawing that line. Really, the surprise to me wasn't with respect to the medically licensed centers, but the other half of the case, which had to do with the unlicensed centers. All they're doing is providing diapers and baby food and clothes and things like that. They're not doing pregnancy testing or anything else medical. And there was this great colloquy at oral argument where Justice Sotomayor was actually pressing the state of California about what the effect of the mandated disclosure would be for these unlicensed centers. And the hypothetical, which had been posed by another justice, was, say one of these pro-life pregnancy resource centers wanted to put up a billboard that simply said, "Choose life," and nothing else. After being really badgered by a number of justices, and concluding with Justice Sotomayor, the attorney had to admit that under the unlicensed regulation, that Choose Life billboard would also have to include a huge multi-dozen word disclaimer in at least a dozen other languages on the billboard in a way that would completely drown out the simple message that they wanted to express. And all 9 justices at the oral argument really seemed to be offended by that, rightly so. I think we all would be by that kind of compelled speech. And yet even that issue only got 5 of the 9 justices. 4 justices were comfortable allowing the government through a political scheme to drown out someone's political message. That was really the most surprising aspect of the opinion to me.
Amanda, could you just briefly address the unlicensed clinics and whether there is a good argument for the regulation that John was just talking about?
I think it goes to whether or not both whether or not you think that this is political speech as opposed to sort of like a regular, a type of regime that's aimed at disclosing important facts in the regulation of professional life. So we actually let the state heavily regulate doctors, okay? And so the idea is that women may go to these clinics thinking that there's a doctor there, and can the state require a clinic that doesn't have a doctor to basically post a sign that says there's no licensed medical profession there? And I think that, it's a hard question, right? Like the state really can regulate the professions, but the court viewed this more as a regulation of the political activity of an organization, so sort of broadly construed what was contained in that context. But I do think throughout, and you see what the dissents were about, is that this may not be, I think, movable beyond the abortion context. The court reaffirmed the Zauderer standard, which is the idea that disclosures in economic life do get lesser scrutiny, and including towards health and safety warnings, so things like nutrition labels and what have you. I don't think that this case means that those types of things are going to get stricter scrutiny. I think that this case really is about the particular context of the highly morally and politically fraught question of abortion, and I think that's why you saw it come out the way that it did.
Okay, let's jump over to the Janus case, where the court, of course, said that public sector workers have a constitutional right not to pay agency fees that help cover the cost of collective bargaining. Scott, why is there a problem if these fees were just going to the cost of union representation and not to political or ideological activities? Why is there a First Amendment problem?
Well, I think this was one of those cases that a lot of court watchers kind of saw where this was going. And I think it's also emblematic of how the Roberts Court has been when it is thinking about reconsidering a precedent, it will put some hints out there. And that was exactly what happened here in a case a few terms ago, that this was a potential case that could be reconsidered, the Abood precedent from decades ago. And the argument is pretty straightforward. It is something along the lines of that, money is going to be fungible, and when you are funding an organization that is engaging in views that you might disagree with, well, that is going to be the equivalent of compelling you to not only associate, but also give resources and therefore speech, or at least the resources to engage in expression to that organization. And in that sense, it is compelling the association and the speech, even though there would be, I guess, some form of discretion on how the organization spends its money. Although it'd be interesting to see then, is this going to be only overruling one particular case in the union area, or is this going to have broader implications? You can imagine all sorts of different areas, particularly I would imagine the college, university setting, where there are going to be certain fees charged, and if an objector doesn't want their money or fees to be used in a certain way, similar to the union scenario, well, what happens in that situation? The court has had a few of those cases in the past, but I think one aspect of this because all of these cases, as you clearly see, have some broader implications outside of the exact facts that they have, and so in some ways we're up here trying to speculate, well, what is this going to be for cases outside of the union context? And like many of the cases from this past term, it's hard to say, but I think it does show that the Supreme Court is continuing that trend that you mentioned from the last, say, 5 decades or so of being very protective of First Amendment rights in a pretty expansive way. I mean, we take it for granted here in America, but I mean, America is the most speech protective country in the world. And I know other countries, look at our system and they think that, well, maybe the Americans protect speech too much. And I know we obviously have qualms with how other legal regimes are established. But I think what happens is when you have a Supreme Court that is protecting free speech to this degree, I think it does make sense that the Abood precedent under those circumstances would fall.
Amanda, do you agree with the suggestion of Scott that we may have opened, he didn't say Pandora's box, but have we opened a Pandora's box with this ruling, and it's going to have all sorts of implications that...
I doubt it. I mean, unlike the other cases we've discussed, Janus it fell the way that it was very much anticipated to fall. So I don't know how much you all know, but Abood was this case from, 4 or 5 decades ago that basically looked at the context of public employers and the speech and governmental rights at stake there and said there's not really just one speech right, there's a number of them, and there's governmental interest to regulate their workplaces, right? So governments just, unsurprisingly, have greater power to regulate their employees' speech than they could regulate a regular citizen's speech. Okay, so like if I'm a government lawyer, I can't just say anything in court that I want to, right? No, of course not. They can regulate that greater. And what Abood did was it crafted a compromise that said unions can't charge employees for political speech, but they can for the basics workings of sort of like the order of the workplace, so like for a grievance. And the thing about unions, which you may not know, is that they're legally required to pay for a bunch of things even for employees who are not union members. And the question is, the stuff that they're required to pay for, can they basically let everyone pay their own way, or do they have to shoulder the burden of everyone? And Janus came out in a way that basically said, under the First Amendment, you thought you had a right to free speech. No, you have a right to something for nothing. You have a right to actually get stuff from a union and not pay for it, stuff the union's required to pay for you. And in that way, I very much agree with Justice Kagan's dissent, which says the First Amendment is meant for better things. I think it's meant for a lot of different ends as opposed to just forwarding the rights of one set, a particular anti-union view. And in that way, I think the case is much more likely to stay in the union context because I think it was motivated by certain political views about unions.
John, if you don't have something burning to say about the Janus case, we need to open up for questions in a second. Sure. And I want to just take a minute to ask a kind of a bigger picture question to give each of you a chance to say, is there some unifying theme here? So we have seen in the last few years the First Amendment, particularly the speech clause and the free exercise clause as well, really used as a tool for the court's conservative wing. Is there some way to sort of tie this together? What is going on? Are liberals suddenly now more opposed to speech and all their laws need to be struck down under the First Amendment? What is happening in our jurisprudence big picture that is causing this to happen? And we throw that out for any of you who'd like to comment on it.
I'll start. I really do think it's the pluralism piece that Justice Kennedy was pitching, because in at least the 3 cases we've spent the most time talking about today, Janus, NIFLA, and Masterpiece Cake Shop, it was about the government forcing the little guy or the little girl to do something that they didn't want to do. In NIFLA, it was these tiny pro-life pregnancy resource centers, which were being pushed around by the California government. In Masterpiece Cake Shop, it was the small cake shop proprietor being pushed around by the Colorado Civil Rights Commission. And in Janus, it was government-sponsored unions, essentially, forcing employees to give over their hard-earned dollars to negotiators who would then present requests to the government that that person vehemently disagreed with to the core of their political being. So I think in each one of these cases, the majority is saying, why can't we all get along? You don't have to force someone to pay money to to have someone speak on their behalf when they disagree with it. Or if you're the Pregnancy Resource Center, you don't have to coerce them with the government's message. California can put out its own message about the availability of government-subsidized abortions. So whether this is a long-term trend, especially in a post-Kennedy court, it's anybody's guess. But I think the message is, why can't we all get along?
I think it's because the First Amendment is really open, right? It protects the freedom of speech, but it doesn't define what that means. And humans are speaking, communicating, expressive animals who can express almost anything in what they do, but also that means government regulation can be construed to be regulating speech or expression in almost any case. I think what's interesting, what you've seen in the First Amendment, is that you've seen, there's a scholar at UVA that says that basically for that reason, it's become this sort of like opportunistic tool of both sinners and saints alike, right? Is we've tried to cram a bunch of stuff into the First Amendment because we can't bring it other places. And I think some of the economics rights cases are actually a product of the court's turn in the 30s and 40s away from allowing economic liberties claims under other parts of the Constitution. And I actually think a bunch of the sort of like more religious liberty First Amendment claims are because as the court took a pretty sort of like more rights, strong rights turn in the 60s, that those things have now, that's expanded. And so we've sort of like brought a confluence of the 60s left and both economic and faith-based right movements. And that's why we've seen sort of the growing use of the First Amendment today. But whether or not that'll continue, I think is a great question.
Very briefly, I think some of this is also just the nature of, we're talking about a very limited data set of cases that reached the Supreme Court at about the same time. And so today we're talking about these particular cases. But I think a theme, and this goes for whether you're liberal, conservative, whatever, there are aggressive uses of government power that I think both liberals and conservatives could point to say that maybe government shouldn't be doing that. I think some of these fact patterns can go along those lines, but we could go back to past terms and also come up with some examples there. But that's all to say that I think the court is, I hate using the word taking seriously, so I'm not going to say taking seriously, but what I think what the court is doing is it's trying to actively protect individual liberties. And I don't think that's a bad thing.
We have some time for questions. There are a couple microphones out there, and so raise your hand, I'll call on you, but wait until the microphone gets there before you start asking your question. In the back.
Hi, Jordan Lawrence from ADF. I have a question about NIFLA for any of you that want to comment on this. That the case was presented as a compelled speech case, but there's sort of this interesting twist where it was struck down as a content-based exclusion, which I guess it is, but it seemed like kind of a more roundabout way to do it. And then there's that interesting concurrence by Justice Kennedy where he raised a viewpoint discrimination argument. And I'm just curious as court watchers what you think was going on there with all that. Why didn't they just say, this is compelled speech, and that be the end of the analysis?
Well, I mean, maybe for one, they had Masterpiece Cake Shop where they specifically avoided a compelled speech rationale, and so maybe that accounts for it. But of course, the passage I read from Justice Kennedy's concurrence absolutely was going down the compelled speech route. And as far as Justice Kennedy on viewpoint discrimination, I think most would agree that Justice Kennedy in his time on the court was maybe the most protective of free speech rights. So the fact that Justice Kennedy may have seen something as even, an even more egregious violation of the First Amendment, that may be that it was just because of Justice Kennedy's views about what the First Amendment itself protects.
Hi, my name is Eric Peterson. I work for the Institute for Free Speech. One of the interesting parts about NIFLA and some of the dissents you've been seeing is this idea that the First Amendment has a positive right to speech. In fact, that when the court ruled against that, they were hiding information from people who want it. What do you think the chances of that legal argument kind of gaining traction in the Supreme Court and other legal circles is?
Want to take a crack?
I'm not sure I understand the question. You mean that women have a positive right to information?
Right, exactly. And that the court's ruling for NIFLA was preventing those people from expressing their speech rights.
So I didn't understand the court to be saying that they were preventing those people from expressing their speech rights. So within commercial speech, it's long been established that there's actually no First Amendment protection for false or misleading commercial speech at all. So like if I'm selling you something, I can't tell you that my snake oil cures cancer. because of that informational interest on behalf of consumers. And so there are essentially two bodies of case law that ran into each other in NIFLA, which is one that says sort of like that treats both compelled speech and restrictions on speech the same in political life. So it's the court treats equally the idea that I can't say something as I'm required to pledge allegiance to the flag in political life, but in economic life there's an asymmetry between how the court treats compelled speech versus restricted speech, which is to say the standard for nutrition labels is pretty low, and then the standard for for compelled speech in commercial life is pretty low, whereas the standard for repressing speech in commercial life, so like the government's regulation of commercials, has a higher level of review. And I think basically in this case the court viewed this more as a political speech case, and so saw those things closer together.
Okay, question there.
My name's Alex Mansfield. I think this is on. Yes. Name's Alex Mansfield. So I have a kind of broader question going back to Justice Kennedy. And I've been really fascinated just going back over his jurisprudence where, he obviously is very concerned about protecting historically oppressed minorities. But then his final note on the court has to do with preventing compelled speech. And so where you have historically oppressed minorities, how do you protect them? It's by compelling action. But it would seem that his final note was basically, saying, almost defanging the tool that would be used to accomplish the thing that he originally wanted. So I kind of see those as two tensions between inside of Kennedy, and I was wondering how you would resolve that, and maybe if you would say fall more on the couple's side in the Masterpiece case, could you present a limiting principle that would protect the cake maker's rights? But then if you would fall more on the cake maker's case, whether you could come up with a limiting principle that would protect the minority group.
Well, you're the Kennedy guy.
Yeah, oh, that's good, yeah.
Let me try to say it this way. I think Justice Kennedy was deeply concerned with, and this is a paraphrase of what he said in Lee versus Weissman, which is tolerance in a pluralistic society. And I think that is what would explain why there is this is this tension between, you have a minority group who is, action is being taken or inaction that is having an effect on that group. And again, as I said earlier, I don't think it should be minimized what's happening, but I think this is also why this is such a tough case. That on the flip side of that, in a pluralistic society, there has to be also a tolerance of viewpoints. And then how does that play out? And in what ways is that allowed to play out in society? And I think you can have reasonable debate about those things. And I think at least what the U.S. Supreme Court has done in the free speech context is it, at least up to this point, has always, I shouldn't say always, but almost always erred on the side of protecting the free speech right. Justice Thomas's separate opinion has a line in it saying something along the line of, well, the court was never worried about stigma when we were saying there was a free speech right to burn a cross. I think that's another way of saying if the court is going to be protecting free speech to that degree, that itself is trying to further a pluralistic society. And I think that's why there's the competing interest that if you see it as not just a free speech case and you don't see it just as a same-sex wedding, same-sex couple case, but you see it as, wow, what do you do about tolerance in a pluralistic society? I think that's how you do get to the point where you do. As far as how to draw a line to resolve those, I'm not sure at the end of the day that there's going to be a satisfactory line that can be drawn for either side that would account for every value together. But that, again, is why this is such a tough case to begin with.
Justin, I don't think Amanda would agree with the premise of your question, would you, that he has defanged the tool in the Masterpiece case? You described Masterpiece as sort of reaffirming the basic structure that you can't opt out of these generally applicable discrimination laws.
I don't think that he defanged the tool. Like all of the language in the beginning of the opinion in Masterpiece reaffirms the idea of the sort of like continued constitutional principle that anti-discrimination laws don't raise constitutional concern. So I don't think it's been defanged. I do think it's interesting to his paragraph in the travel ban case, which to me was a defanging. Like his paragraph in the travel ban case, I thought was really interesting as the end of his. I don't know if you have thoughts about that, but that he says, even if the courts can't enforce pluralism, we hope that governmental actors will do that, even though he's in a position right now actually to do that. And I thought that that was really an interesting move from him, from someone that I do see, and I see that in Masterpiece, where he was really trying in a kind of like elder statesman type way to broker a deal.
Here in the front.
Thank you all. Tyler O'Neill from PJ Media. I'm going to throw a question out there that I'm sure is going to get a lot of fire, but we're seeing in arguably from some sides in NIFLA and Masterpiece, and then with California's law HB 2943, a lot of Christians and conservative Christians in particular start to think of themselves as almost an oppressed minority. And that's a very interesting position for a lot of reasons. But there's actually been some studies, this book, Too Many Christians, Too Few Lions, documenting anti-Christian animus. My question would be to Amanda, how do you interpret these events without buying any of that and explain why they think that way? And then to Scott and John, how do you address, like, you're defending people's rights, but maybe that's going too far?
So I think that that's probably one of the reasons that the court took the Masterpiece case, or is this idea that sort of like the court's done a lot for gay people, and I think there's a big faith-based community that feels that who feels that that has been too far, and that feels sort of like entrenched in a bunch of different ways. So this is what I'll say about that, is I think that that's the reason why the court probably took the Masterpiece case, and I think that it actually presents a hard question on that front, because what the court eventually said, which I think is the right decision, is that in political speech life, including like NIFLA, right, you have all of your very protected freedoms to express your opinion, to sort of like to live your faith in as many ways as you can, right? But in economic life, when you open a business to everyone and you sell stuff, you have to sell the same stuff. If you're going to sell something, you also have to sell it to everybody else. And that presents a hard question in these particular cases, but I think it was the court's goal to foster some of this kind of like everybody get alongness that accepted the case. And I think once they realized that it was harder to divide that up, except by saying in political life you should express all of your views, in religious lives you should do that, but in economic life it's very hard for us to say, well, except for in this particular context. And that's why I think the opinion came out the way that it did. But I think it's a real question. It's a really important question today about how kind of like a bunch of these different, both the different legal questions, but also the big social question will unfold.
Yeah, I do agree with the reason why they took Masterpiece. I think that the court, and maybe Justice Kennedy in particular, felt like the pendulum had swung too far. Mm-hmm. One of the interesting things about Masterpiece is that it went through multiple conferences. I don't even remember, like 15, 16, somewhere in that neighborhood. So it was clear that they were struggling with making the decision whether to take the case or not. I think the promise of those who were asking the court to create a brand new constitutional right out of whole cloth in Obergefell was that same-sex marriage wasn't going to affect anybody else. And I think what the Christian community quickly realized is that once the opinion came out, it went from I want a constitutional right to everybody has to accept this and endorse it and participate in it, or otherwise you're going to be shunned from society. And we see Christians, getting fired from their jobs. Chief Cochran down in Atlanta is a great example of that, but there's many others. Or in some of these cases, you don't have to just make the cake. You actually have to sing at the wedding and embrace what you consider to be a sacrament according to your particular beliefs. So the pendulum had swung a long way, and I think Masterpiece does a very nice job of bringing that pendulum back a little bit to say this doesn't go all the way. There are protections for the minority religious communities. We've always acknowledged that in this country, and we're going to continue to respect those going forward.
More questions? Well, I'll ask one more. I have a line here out of Justice Kennedy's opinion in Masterpiece, where he says, "Our society has come to the recognition that gay persons and gay couples cannot be treated as social outcasts or inferior in dignity and worth. And I'm sure that is a line that Amanda hears, and she thinks, yes, this is the court reaffirming this basic structure and the things it said in Obergefell. And my question for John and Scott is, that line is going to show up in a lot of briefs, I would think, in cases like Arlene's Flowers, where somebody will say, when I can't go to Arlene's Flowers and to get flowers for my same-sex wedding, I'm being treated as a social outcast, inferior in dignity and worth. What do you do with that sort of language in this opinion?
Yeah, that's a great question, but not difficult to solve, because if you talked to Barronelle Stutzman, if you talked to Jack Phillips, they would say they agree with that line. Their Christian faith requires them not only to refuse to engage in a religious ceremony that violates their deeply held religious beliefs, but also to treat everybody with the same dignity and respect that God would ask of them when they're in front of them, regardless of their race, their ethnicity, their religion, or even their sexual orientation. So I think what someone like Barronelle Stutzman would say is, of course, my customer Rob, I loved him like a friend for 9 years, did everything that I could for him. All I'm asking in these cases is that you don't deny me my inherent dignity to exercise my religious beliefs in the public square, because not only is that contrarian to everything that our country was founded on, that people of faith could bring their gifts and practice them in faith in the public square, but it's going to do a tremendous amount of public harm. When you think about what religious organizations have brought to this country in terms of public universities and libraries and research and foster care systems and hospitals and homeless shelters and food banks, and you could go on and on and on. If you continually force folks in that space to withdraw from the public square because they can't embrace something as part of their religious identity, we all lose from that. And so I think ADF's clients would embrace that statement and say, yes, God does require all of us to treat everyone with love and dignity, but that includes those with religious beliefs.
We probably have time for one more question if somebody has one.
I just wanted to ask about the public conversation around the Masterpiece case particularly. Amanda, you had mentioned that you agreed that Jack Phillips at least was not, that he wasn't barring people from service on the basis of their orientation. At least that was not what he was attempting to do. But the public conversation around the case seemed to be very different. And my sense is that when we see these cases go up, the litigants have on both sides, have a certain more nuanced understanding of what's actually happening. But it's hurting our public dialogue with a lot of these cases because people allow the dialogue to be such that people think that the actual division in our society on these cases is enormous when it's actually a lot more narrow than it seems. And was curious as to any of your thoughts on that. How do we do a better job of actually framing for people what the real stakes are in some of these cases, that even if it's big, is a lot more narrow than people think it is?
That's a really hard question because it really reflects the broader problem that we're having with politics in our country. That one side is getting their information not only about these legal cases, but also about what's happening in Washington, D.C. on a day-to-day basis from one set of news sources and social media, and the other side is getting it from another, and never the two shall meet. I don't have an easy solution to how we bridge that divide, but we better find it soon because we're quickly turning into a society of two cultures that not only are at odds with each other, but can't even communicate with each other anymore. And one of the beautiful things about these Constitution Days, events that the Federalist Society holds, is that it brings people with different viewpoints together to talk rationally, intelligently about these things. And I wish we could see a lot more of that, not just in the context of U.S. Supreme Court cases, but all of the issues that we're dealing with as a country.
So the answer is more panel discussions, and the good news is you'll have another one in 15 minutes, I'm told. So I want to thank our panelists, and thanks everybody for the great questions.
Yeah, really nice to talk to you.
As Associate Administrator of OIRA. In that role, he reviewed major regulations and helped to coordinate regulatory policy. Prior to his government service, Mr. Harris was a partner at Bancroft and then at Kirkland & Ellis. He also served as a law clerk to Chief Justice John Roberts of the U.S. Supreme Court and to Judges David Sentel and Lawrence Silberman of the D.C. Circuit. As relevant here today, Mr. Harris recently served as counsel of record for an amicus brief on behalf of a group of Maryland elected officials in support of the American Legion's petition for certiorari in the Bladensburg Cross case. Next is Mr. Alex Luchenitzer, the Associate Legal Director at Americans United for Separation of Church and State, where he has litigated church-state lawsuits since 2001. His cases have challenged religion in public schools, public funding of religious activity, government sponsorship of religious displays, and discriminatory governmental prayer practices. Mr. Luchenitzer has also defended women's, LGBTQ, and other civil rights against religious-based discrimination and deprivation. In addition to litigating these issues, he has addressed church-state issues in amicus briefs, journal articles, blog posts, television and radio appearances, major newspapers, and public presentations. Next is Mr. David Cortman, who is Senior Counsel and Vice President of U.S. Litigation at Alliance Defending Freedom. Mr. Cortman joined ADF in 2005, and he currently supervises a team of nearly 40 attorneys and legal staff who specialize in constitutional law, with a focus on religious freedom, sanctity of life, and marriage and the family. He has successfully litigated hundreds of constitutional law cases in all levels of federal and state court, including at the U.S. Supreme Court. Most recently, Mr. Cortman successfully argued Trinity Lutheran Church v. Comer, where he secured a 7-2 victory. He also argued Reed v. Town of Gilbert, where he secured a 9-0 ruling that prohibits the government from discriminating against religious speech while favoring political speech. Mr. Cortman has appeared as a guest and has written opinion pieces for numerous major media outlets. He also teaches a legal course on the U.S. Constitution and civil rights. And finally, our moderator today is Miss Amy Howe, who many of you may recognize as the co-founder of SCOTUS blog, the preeminent blog devoted to coverage of the U.S. Supreme Court. Until September of 2016, Ms. Howe served as editor and reporter for SCOTUS blog, and today she continues to serve as an independent contractor and a reporter there. Before she became a full-time blogger, Ms. Howe served as counsel in over 24 merits cases at the U.S. Supreme Court, and she argued 2 cases there. From 2004 to 2011, she co-taught Supreme Court litigation at Stanford Law School. And from 2005 to 2013, she co-taught a similar course at Harvard Law School. Ms. Howe has also served as an adjunct professor at American University's Washington College of Law and at Vanderbilt Law School. And with that, let me turn it over to Ms. Howe to dive right into the Establishment Clause.
All right. Thanks, Caitlin, for the introduction. I have to say that as a Supreme Court reporter, with everything that's been going on the last few days, it's great to have a chance to talk about something uncontroversial like religion in public life. I'm going to start with a short background on a couple of the cases that we're going to be talking about today, and which Caitlin already referenced. The first is Rowan County versus Lund. Rowan County is in North Carolina. It has a board of commissioners that meets twice a month, and before they get down to their official business, they start with a prayer led by one of the commissioners who take turns. And the prayer usually begins with something along the lines of, "Please pray with me," or "Let us pray." Several community residents objected to this prayer practice. They filed a lawsuit in federal district court. The district court agreed with them that the practice violated the Establishment Clause. They went to the Fourth Circuit, where a 3-judge panel reversed that ruling, and then they went en banc to the Fourth Circuit, which by a vote of 10-5 reinstated the district court's ruling in favor of the challengers. I'm just going to give you a snippet from the opinion by Judge Wilkinson at the en banc stage. He wrote that the prayer practice served to identify the government with Christianity and risked conveying to citizens of minority faiths a message of exclusion. And because the commissioners were the exclusive prayer givers, he wrote, Rowan County's invocation practice falls well outside the more inclusive minister-oriented practice of legislative prayer described in Town of Greece versus Galloway, which was the case a couple of years ago, in which the Supreme Court rejected a challenge to a New York Town Council's practice of starting its meetings with a prayer led by chaplains from the local community. The county went to the Supreme Court, filed a petition for certiorari in October of 2017. The case was rescheduled, that was put off so that the justices didn't consider it at a conference until June of 2018, 15 times. Finally, at the end of June 2018, the justices considered it at a conference, they relisted it once, and then they denied review. Justice Clarence Thomas filed a dissent from that denial of review, which was joined by Justice Neil Gorsuch. They both would have granted review. Justice Thomas wrote that the only difference between this case and Town of Greece is the identity of the person leading the prayer. And he added that for many years, we've had a tradition of legislative-led prayer. So that's the Rowan County versus Lund case. The second pair of cases involves the Bladensburg Cross, which is also known as the Peace Cross. It was erected in 1925 in Bladensburg, Maryland, which is a suburb of D.C., to honor the 49 soldiers in Prince George's County, Maryland, who lost their lives in World War I. It's a Latin cross. It contains the names of the soldiers who were killed and some quotes from Woodrow Wilson. It stands on public land. In 2014, the American Humanist Association and a couple of local residents filed a lawsuit in the Supreme Court, filed a lawsuit in federal district court, alleging that because the monument is in the form of a cross, it endorses Christianity, therefore violates the Establishment Clause. The district court ruled for the American Legion and the Parks Commission, which maintains the cross. It said that when you look at the purpose and the context of the history of the monument, it's clearly secular. The Fourth Circuit reversed, holding that because it's in the shape of a cross, it endorses Christianity regardless of the history and the context. So the Commission and the American Legion both went to the Supreme Court, and calling the lower court's ruling grievously incorrect. Those cases are going to be up before the justices at their conference next Monday. So we could hear something if the Supreme Court sort of follows the practice that it has for the last couple of years. We could hear something as soon as Thursday, September 27th. And then just to keep things a little more interesting, yesterday the city of Pensacola, Florida, filed its own petition challenging the 11th Circuit's ruling that the city's failure to remove a cross that has been in a city park for 75 years violates the Establishment Clause. There is an all-star team of lawyers on these three cert petitions. We've got Michael Carvin and Jones Day representing the American Legion in the Bladensburg Cross case. Neil Katyal of Hogan Lovells represents the Parks Commission in the Bladensburg Cross case. And then the Beckett Fund and Professor Michael McConnell represent the city of Pensacola, Florida. We have an all-star team here to discuss these cases and the Establishment Clause more generally. We're going to start with opening statements, for lack of a better word, from each of them. Then we'll sort of have a conversation amongst ourselves, and then we'll open it up for questions with about 15 minutes to go. So, Jeff, are you going first? Or is David?
Sure, you can go first.
Sure, I'm happy to go. So I can introduce the cross case in a little more detail. Thank you to ADF for having me here, and to my fellow panelists. Looking forward to a good discussion. So just to give more of my side's stylized factual background of the Peace Cross. So it's important to emphasize this is a war memorial. It's located in Bladensburg, just outside the D.C. border, and as Amy said, it was built between 1919 and 1925 by local citizens who got together, raised funds, and wanted to honor those killed in World War I. And the reason it's shaped as a cross is not for some evangelizing or proselytizing purpose, but because many of the grave markers in U.S. cemeteries in Europe for those who died in World War I were in the shape of a cross, which was a new development at the time. And so that's why in commissioning this monument, they decided to do it this way instead of some other shape or format. So, and then inscribed on the base of the cross, as Amy said, there's a quote from President Wilson, and then the words valor, courage, endurance, and devotion. So this monument, it's not part of a church. It was not used for proselytization or evangelization, and has nothing to do with religious ceremony or doctrine. It was and is a war memorial, and it's currently in an area surrounded by other war memorials. And in fact, it's where citizens of the local community come together to celebrate Memorial Day and Labor Day. So the Fourth Circuit nonetheless found that this was unconstitutional, and I just wanted to focus on a few pieces of the court's reasoning. So first of all, the panel doesn't quite say, but comes pretty darn close to saying that a Latin cross is per se religious or per se sectarian because it's, quote, the preeminent symbol of Christianity. And so I think that leads to some really odd outcomes. I think as a result of that reasoning, what Bladensburg would essentially have to do is pick World War I among every armed conflict of the 20th and 21st century and essentially pick that one for removal from this area with all the monuments just because the people who commissioned the monument designed it in the shape of a Latin cross. So I think that really gets to some of Justice Breyer's concerns in Van Orden. He seems to view the Establishment Clause as preventing divisiveness in public life and sort of bringing people together and preventing people from being driven apart. But I think it's hard to see how this ruling achieves this when, again, you need to pick one war, essentially, and say this one doesn't get a monument here because of the shape of the memorial. So the second thing I would focus on in the Fourth Circuit's reasoning, there's no question this is a large cross. It's made of concrete. It's 40 feet tall. It's definitely an imposing monument. And I think there was a real sense that came through in the Fourth Circuit's opinion of it's just too big. You know, as you're driving around, you just can't miss it. It's right there. It kind of looks you in the face. But I think that just overlooks some of the really important history of how it got there, which, again, even Justice Breyer said is critical. So when the cross was built in the early 20th century, it was at the very end of a veterans highway in what was then a very small community miles outside of DC. And then through no fault or intentional act of the government, now that area is very developed. Now it's kind of in the middle of an urban area. It's at a major intersection. And so as all of a sudden it went from, this memorial kind of off by itself to kind of in the middle of things. And so I think we have this weird dynamic, and I think it's really a radical proposition that something can essentially evolve into an Establishment Clause violation based on changes in the surrounding area that really had nothing to do with the government's action and certainly nothing to do with any endorsement of religion. And then the last thing I'll say about the reasoning is the Fourth Circuit again and again and again quoted the famous or infamous wall of separation line from Thomas Jefferson, which there's a letter that Thomas Jefferson sent to a congregation in the early 1800s where he referenced a wall of separation between church and state. And that reasoning had sort of its heyday in the 70s and 80s, but has essentially been repudiated and or ignored since then. I think it sort of reached its heyday, and there's a case in the 80s, Wallace v. Jaffrey, where the court struck down even a non-denominational minute of silence where students could meditate or engage in silent prayer, and based on that sort of theory said even that went too far. But the wall of separation language hasn't been used in a majority opinion in a Supreme Court opinion in decades, but yet the Fourth Circuit sort of again and again said if we don't do something about this cross, it'll interfere with the wall of separation between church and state. And I think the history of the Establishment Clause is a bit beyond the scope of the panel, maybe, but I think Justice Rehnquist in Wallace v. Jaffrey really took on this reasoning pretty head on and said when Jefferson was talking about the wall of separation between church and state, what he was really talking about was between the federal government and religion. And then there's even some early evidence where the federal government was both doing religious proclamation type things as well as even funding certain missionary and sectarian projects with respect to Indian reservations. So I think this wall of separation just kind of reappeared in the 20th century, and I think is largely I think been pretty discredited at this point. But that was central to the Fourth Circuit's reasoning. And then finally, the last thing I'll say is parades of horribles are often just hyperbole when you see it in an opinion or a brief about all the awful things that could happen if a decision stands. But I think two of the most prominent World War I memorials in Arlington Cemetery, which is, of course, federal land, are in the shape of a Latin cross. And so the Fourth Circuit tried to distinguish those on fact-specific grounds, in part because they're smaller, so 40 feet versus 20 feet or 30 feet. I found that extremely unpersuasive. I think the court was really straining to say why this cross has to go, but the ones in Arlington Cemetery are fine. So I think if we reach a world where you can have a World War I cross on federal land in Arlington Cemetery, but not on state land in the War Memorial Park in Bladensburg, I think that's more of an indictment of the doctrine than anything else. So I'll stop there for now.
Alex?
Okay. Yeah, thank you for having me. I'll talk about the cross case first and then about the Rowan County case. So in the cross case, the Fourth Circuit got it right. This cross is over 40 feet tall. It towers over one of the busiest intersections in Montgomery County. The other monuments in the vicinity were far smaller, are separated from the cross by highways, and do not represent any other religions. The cross is owned by a public body, and that public body has spent a six-figure sum to maintain it. A cross is the core symbol of Christianity. It is an exclusively Christian symbol. It does not symbolize any other religion. Using a cross as a war memorial honors only Christian soldiers and sends a message to veterans of other faiths that they and their religious beliefs are not valued equally. And to argue that a cross is not exclusively Christian or is not an exclusively religious symbol may be offensive to many Christians. Indeed, some Christians may be offended by using the cross as a symbol relating to war in any manner. Now, will the Supreme Court take this case? I think it's hard to predict. The court has passed on other cross cases over the years, so I don't know whether that'll mean that they'll think it's time to take one or whether they'll keep passing. And I don't really see a solid case that there's a circuit split here, as no circuit has upheld the display of such a large, prominent cross as this one. And there are also some problems with the procedural posture of this case that may weigh against Supreme Court review. There's no final judgment yet. No remedy has been ordered, and the court might want to see and wait to see what the remedy will be. Perhaps the cross could be sold to a private party, or other objects could be added around the cross that would honor veterans of other faiths and of no faith. Indeed, the state added two 38-foot tall soldier statues near the cross while the case was on appeal. So the display is now different from the one that the Fourth Circuit considered on the record before the panel. The Supreme Court might want to give the circuit an opportunity to consider whether the addition of these statues changes the result. Also, the cross is in poor condition. Some chunks of it have fallen off. There are some cracks. And it appears that the state isn't sure whether it's physically or at least economically feasible to repair it. So there might be other changes to the display while the case is pending. All that said, the court might simply find the case interesting and take it in spite of all those things. But it could elect to wait for another cross case, such as, for example, the 11th Circuit case that Amy mentioned, where I believe the cert petition was just filed this morning. And this was a case where the panel struck down the cross, so there's still no circuit split, but the panel urged, two of the judges in the panel urged the whole court to hear the case en banc. So this might be a situation where the Supreme Court might want to wait and see if the 11th Circuit takes the case en banc, and if so, whether there will be a circuit split after that. Now back to the legislative prayer situation, the Rowan County decision. Again, the Fourth Circuit got it right in that case. The prayers there were given by county commissioners themselves. The prayers were exclusively Christian and sometimes proselytized Christianity and suggested that other faiths are inferior. The commissioners told attendees to rise for the prayers and often invited them to pray. This occurred in an intimate municipal environment where zoning and permit applications were often heard right after the prayers. Rowan County's practice affiliated the county commission with one particular faith, Christianity. It sent religious minorities in Rowan County a message of exclusion, that their representatives favor the Christian faith above all others. It put government officials in the business of composing prayers, which is a task that should be left to private ministers. And the commissioners violated the Establishment Clause's prohibition against religious coercion by directing audience members to take part in the prayer. Now, why didn't the court grant review, even though the Sixth Circuit reached a different result in the Bournemouth versus County of Jackson case that presented similar issues? Well, maybe the court thought it was too soon after Greece to take another legislative prayer case. Maybe he wanted to wait and see how other circuits would address similar issues in the future. Maybe there just weren't 4 justices that were troubled by the result in Lund. And the court didn't want to take the Bournemouth case because there were issues about what was properly in the record in that case because the plaintiff was pro se. But I'm sure there'll be other cases in the legislative prayer area that'll give the court a chance to revisit those issues if the court is so interested. And as far as the various comments about what the test should be, I think I'll wait for further discussion and turn it over to David.
Thank you. I want to take us out of the weeds a little bit, and I'm going to kind of bring us up to the 30,000-foot level, if I may. Want to talk a little bit about the Establishment Clause, and I'm sure we're going to get to a deeper discussion of both of those cases. But it's been argued by some that the Establishment Clause is not meant to be a personal right, an individual freedom such as the Free Exercise Clause or the Free Speech Clause, but rather it's a structural limitation on government, such as federalism and separation of powers. It's not the right of an individual to complain that what has been done in general. Most of the time, the court requires a personal injury, an individualized injury, the court has said, before you can come to court, not some generalized grievance that's in common with everyone. And the reason that I bring that up is that has directly to do with standing, as Amy mentioned before, because one of the issues that's often in these cases, does the complainant have standing? Do they have a personal stake in the outcome? Do they have an individualized injury that allows them to go to court and to bring this Establishment Clause violation? So this has come up in many different Establishment Clause cases. In fact, there was a case where ADF litigated, and I think Americans United actually filed an amicus brief against us. But we basically argued it was a challenge to a school choice program where they have these 501c3s that are set up, and you can donate money to them, and they get a tax credit for it. It includes all not-for-profit 501c3s, including religious ones. ACLU brought a case on behalf of a couple of offended taxpayers and said, well, this violates the Establishment Clause because you're allowing this money to go toward religious organizations. And after all, this is government money, so the government is in turn supporting religion through its finances. And so we argued that there was no standing, there was no personalized injury, and the Supreme Court basically stated they rejected Americans United position and basically held there was no taxpayer standing there for those reasons. There was no individualized, personalized injury toward the specific taxpayers there. And so that's important because one of the arguments made in that case was I think this was taken on by Justice Kennedy, both in the opinion and the argument. The argument was made by the ACLU that basically all of your money is the government's, and if they decide not to take some of it, that's the same thing as the government receiving your money and spending it. Now, we were a little bit worried about that proposition. We all work pretty hard. I don't like to think that all of my money is the government's, even before they put their hands on it, but that was the argument made. And Justice Kennedy basically said, in response to that, that the position that money is the government's, even if before it comes into the hands of the tax collector, is not supported in case law, nor is it supported by any standing rules, and we shouldn't make it easier to bring lawsuits under the Establishment Clause than any other constitutional provision. So Justice Kennedy has been, through the years, as has the court been, pulling back a little bit on the standing in Establishment Clause cases, making sure that they're in line with other constitutional provisions. In another case that we litigated, the Trinity Lutheran preschool case that you've all may have heard about, Americans United there argued that that would be an Establishment Clause violation there to allow a preschool that was operated by a church to participate in an otherwise neutral government grant program. And basically what they would do is take recycled tires. You would put them down on the floor of the playground to make it safer for kids. And because a preschool that was operated by a church followed all the criteria and got awarded one of the bids, that the claim was that that violated the Establishment Clause. And the argument made by Americans United was, well, there's no secular purpose, and we'll see that Lemon test as we talked about before, but there's no secular purpose at play when it's a church, because everything they do is religious, so you have to exclude them. And of course, we were on the other side and argued the opposite. And the Supreme Court basically held that your preferred policy, the state's preferred policy of getting as far away from the Establishment Clause violation as you can, actually violates the Free Exercise Clause. So not only is it permissible under the Establishment Clause to include churches in a neutral program, but it actually goes so far to violate the Free Exercise Clause to exclude them. And the last one I'll talk about, and part of this is just showing the same Establishment Clause with the same tests that are proffered by the court, the opposing views by different organizations as far as what those tests mean, and then how they're practically applied in a particular case, and what's the result. Is the cross of the prayer violate the Establishment Clause? Does it not? The last one was in Town of Greece, which was one of the predecessor legislative prayer cases that ADF also had the pleasure of participating in. Americans United argued that that practice of legislative prayer was unconstitutional for two reasons. One, it puts coercive pressure, and we'll hear about that in the Jackson County case and the Rowan County case, puts coercive pressure on citizens to participate in the prayers because it's at these local levels of government, and that the prayers are sectarian rather than inclusive. And we'll talk about that because if you look at the history of challenges to legislative prayer under the Establishment Clause, it's taken a progression, right? The first case was Marsh versus Chambers. Are they even constitutional? Can you even have a legislative prayer? It was upheld. The second challenge was, well, maybe you can have them, but you can't have them if they're sectarian. You can't have them if they're Christian. So once the Supreme Court ruled in Town of Greece that that's permissible, now the next stage, which we'll talk about, I think, a little bit today is, well, then who could pray? So now it's okay if you have prayer, it's okay if they're sectarian, but now the question is who could pray? It's okay to bring in outside people or hire a chaplain, but if you have the commissioners themselves do it, well, now it's unconstitutional. And so the next question that will be litigated, which is being litigated, is who can pray? But the court basically rejected those two propositions. They said, number one, it's not coercive for anyone to pray and say, for example, let's bow our heads or let us pray, which is what the court said. It's normal when you're praying to invite other people to do so. It's not coercive. And certainly it allows for whoever the legislators happen to be. In that case, in Town of Greece, they had an open invitation to all the religious leaders. Anyone was invited to pray, but they didn't have to pick and choose to bring in other people of different religions if it was outside the borders of that particular location. So I just wanted to highlight some of the differences between the different folks up here on the Establishment Clause. We'll talk a little bit about the problems with some of the tests. Are they workable? How does it work out where you have one circuit that says a similar type of legislative prayer violates the Establishment Clause, but you go a couple of states away and it doesn't. And I was a little bit surprised that the court didn't take up those cases, because whenever you have somewhere around 30 appellate court judges disagreeing on an issue, that's a perfect invitation for the court to take the case and clarify and clean up that conflict that's there, so the law is uniform regardless of where you happen to engage in that practice.
Excellent. Well, I think we could probably stay here all afternoon, but I want to stay at the 30,000 foot level to make sure that we get to exactly what you've talked about. Justice Thomas, in his dissent from the denial of certiorari in the Rowan County case, called the court's Establishment Clause jurisprudence, referred to it as being in disarray. And then the 11th Circuit judges in the Pensacola case, even though they ruled against the city, 2 out of the 3 judges on the panel called the Supreme Court's Establishment Clause jurisprudence a hot mess. And so, my question, I've got sort of a multi-part question, I'm channeling Justice Breyer here, to you all is it in disarray? How do you fix it? And then I'm listening to Jeff and Alex in particular focus, at a very granular level on some of the facts in these cases. Whatever the test is, it seems like the inquiry could be very fact specific, and whether sort of, if so, by its very nature, it's going to be hard for people, particularly on the outside, to look at it and not think it's in disarray no matter what the test is. So I'm just going to throw that out there to whoever wants to get started.
Well, I think it's important to keep in mind the first principles, because I'm actually a little bit of a skeptic of doctrine. Once you get down the road of balancing tests, obviously the Lemon test has been pretty extensively criticized. It's, 3 factors of the secular purpose, the religious effect, and whether there's entanglement. Then there's a debate about whether Justice Breyer's approach in Van Orden, which is still a totality of the circumstances test, which he views it more as, is this a device? I think it's fair to say he views it more as, is this divisive or something that sort of brings the community together? I think that's largely semantics. I think it's important to keep in mind the structural things of the Establishment Clause, which are, as I mentioned earlier, it was pretty explicitly intended to constrain the federal government, not the state. So I think using it to sort of micromanage what, especially a local government or a state is doing, that I don't think that's what the framers had in mind. And then, as someone else alluded earlier, I think there's a serious question of whether it's a structural right or an individual right. And I think the big concerns driving the Establishment Clause were that we don't want to be a country with an official U.S. religion where then the pastors and government officials are kind of doing unseemly favors back and forth. And so I think when you think about those structural and historical things and then get to something like a passive display of a monument or a memorial, it just seems like I think the doctrine is just completely lost track of the actual history of the clause. And so I think, Justice Thomas has some good ideas. I think the coercion test or something of, is this something where you're not just driving past something, but you're being coerced to essentially support what looks like a state or an official religion. I think that's getting closer. But as between Van Orden and Lemon, I'm a little skeptical that we can parse that out sufficiently well.
All right, Alex, I'm going to guess you've got some different thoughts.
Certainly. The tests that the Supreme Court has used, they've been much maligned, but they provide clear lines for the lower courts to follow. And they're also they're not made out of whole cloth. They are based on the writings of the founding fathers, of Jefferson, of Madison. And there's some key principles that, whether you call it Lemon or something else, there's key principles that I don't think there's any basis to disagree on. First, a government must not favor any one religion over any other. Government must not take positions on religious issues or make religious judgments. Government must not coerce any person to take part in any religious activities or exercises. And government must not aid any religion or fund religious activities. Now, these are all ways that government can act within a purpose or effect of advancing religion. And if you look at that language, purpose or effect, in the abstract, someone could say, well, yeah, this is vague. But if you look at the specific principles that the court has fleshed out over many decades, these are not vague tests, and they give plenty of guidance and clarity to the lower courts. Now, in some of the briefs in these cert petition and the Cross case and other recent cases, there's been arguments that the court should throw out all these existing tests and adopt a history-based test. Well, if the court does so, that would actually give lower courts much less guidance in future cases. The history test, as applied in the legislative prayer context, which is the only place where the Supreme Court has applied it, looks to one principal fact, which is that at around the same time that Congress approved the language of the Bill of Rights, the same week, Congress enacted a legislative chaplaincy and approved a bill that established the chaplains and established their funding. So therefore, the court reasoned, well, since Congress approved the chaplains at the same time as it approved the Bill of Rights, the founders could not have intended the Establishment Clause to prohibit legislative prayer. And legislative prayer has continued since that time through the present, so therefore it can't possibly be unconstitutional. The problem is that if you try to apply that kind of reasoning to other contexts, there's not a whole lot in history to go on. We know that the founders were deeply concerned about the use of public funds to pay for training of ministers or religious education or other religious activity. But there's not a whole lot of federal history on other issues that often come up in Establishment Clause cases. For example, public school cases. We didn't have public schools at the time of the founding. So there's no contemporary history that says, well, this was okay, this wasn't, so you can do this or you cannot do this in public schools. Also, the federal government was not putting up religious displays. They weren't erecting crosses, they weren't erecting Ten Commandments at the time of the founding. So, again, to try to figure out what's constitutional in the religious display area, there's no relevant founding era federal history. All you can do is look at the writings of the founders, and the founders were clearly very concerned about government favoritism of any religion or the government taking a position on religious issues. And the next question is, can you look at what was going on in the states? Well, the answer is no, as both Justice Kennedy wrote in his concurrence in Allegheny and Justice Alito wrote in his concurrence in Greece. Because at the time of the founding, the Establishment Clause did not apply to the states, and in fact, many states had religious establishments, established churches, and in some cases, those churches lasted for decades after our Constitution was adopted. So if you look at what's going on in the states were doing many things that are clearly prohibited by the Establishment Clause. So this history test, and in Allegheny, Justice Kennedy tried to flesh out the history test in this way. He wrote, whatever test we choose to apply must permit not only legitimate practices 2 centuries old, but also any other practices with no greater potential for an establishment of religion. So the idea is you compare the things that we know were done in 1789, which is legislative prayer, and there were some presidential proclamations of Thanksgiving for Thanksgiving Day. And the idea is that you look at other things and you ask, does this other thing have a greater potential for an establishment of religion? And I submit that this is a whole lot more vague and would give lower courts a whole lot more trouble in figuring out what's constitutional and what's not than the existing purpose and effect test and the various details that I spelled out of how to interpret that test, which means no religious favoritism, no religious coercion, no religious judgments, and no aid to religious activity. I'll let you, David, I'm sure you have some thoughts about this.
Just a couple. I do agree it's a hot mess, but I think it's getting better. I think the town of Greece was an important opinion. I think Trinity was an important opinion because Trinity dealt with the interplay between the Free Exercise Clause and the Establishment Clause, what the Supreme Court called this play in the joints, which is some magic place in between, that some sort of action doesn't violate either the Establishment Clause or the Free Exercise Clause. But I want to bring up a couple things. The reason I think, especially the Lemon test, is such a poor vehicle, and it is unclear, as Alex mentioned, the exact same time as the First Amendment is being enacted, including the Establishment Clause, Congress is hiring its first chaplain to engage in legislative prayer. Now, If that's not an indication of the meaning of the Establishment Clause, I don't know what is. I mean, imagine the founders giving their lives and their fortunes, which they all did, to get this great document in place, and turn around saying, we didn't really mean that. Let's go ahead and violate it at the same time we're passing it. It's not what's happening. But yet, here we are 200 years later, and that same practice that began at the founding of our country is being challenged now as an Establishment Clause violation. How could it be? Because the test changed, the history changed, and it's got to be because the test changed. I think Jeff said it best when he said it before. He said we have this evolving, the cross, for example, evolving into an Establishment Clause violation. That's exactly what's happening with legislative prayer. It's evolving into an Establishment Clause violation. Well, that just shows you how poor the test is to make that distinction. Because if history is an indicator, and I don't know how it's not, the only response I've ever heard was, well, maybe they've been violating the Establishment Clause for 200 years. Doesn't seem likely when the founders are the same folks who enacted it, were the same ones who were enacting this legislative prayer with this paid chaplain. But look at the Lemon test for a second. First of all, it talks about, is there a secular purpose? Well, in these cross cases, it's found to be a secular purpose. You're honoring the war veteran. So there's a secular purpose. But then they go to this endorsement test kind of brought forth by Justice O'Connor. And the test is whether a reasonable observer perceives there be to advancement of religion. Well, how many more vague words can you have and throw them together and think that's some sort of standard that you can decide some issue? So a reasonable observer, who is that? Well, it's likely whatever judge you have on the particular court, right? They become the reasonable observer. Whether they perceive, not whether there's an actual violation, but if they think there's one. And how do they look at the facts? Well, they're supposed to know the facts in the context. In the Monument case, the Peace Cross, they basically said, as Amy mentioned, there was a quote on it from President Wilson. There were some different valor and courage and different quotes on it. And the court's response was, well, they know that the reasonable observer knows they're there, but you really can't see them. They're a little faded. They're behind the bush. You can't see them anymore. Well, that's not a reasonable observer. That's an observer who doesn't want to see what makes this a secular monument, in this particular instance. And I want to clarify one thing. The cross is religious. So are the Ten Commandments. It's not the point. It's not that it's not religious. The question is, what's the purpose of it being there? Does it have a religious purpose, or is this religious item have a secular purpose? For example, under Lemon, is it a war memorial? So I'm not one who says, like the Ten Commandments, oh, that's not religious, it's just 10 different rules. Well, no, of course it's religious, but the court said it's okay to acknowledge your religious heritage, but the reason you're doing it is not so people venerate and worship it. The reason you're putting up there is to acknowledge the history, to honor their dead. And I just want to make that clear, because it comes, sometimes people say, well, it's just in the shape of a cross. It is a cross, but it's permissible and should be permissible under the Establishment Clause.
The Trinity Lutheran case was also fascinating because, for those of us who cover the court, because they granted review in the spring, or the February or March, and then kept putting it off for oral argument. And so we all assumed that they thought they were going to be hopelessly deadlocked and were waiting for their ninth justice, and then it was 7-2, so it was not a particularly close case. Speaking of ninth justices, I think it would be basically illegal in Washington, D.C. to have a panel on the Supreme Court and not talk about the effect of Justice Anthony Kennedy and his retirement. So let's talk about that in terms of sort of what a new justice might mean for the arc of the court's Establishment Clause jurisprudence. Is it likely to lend some clarity, perhaps? Anyone?
I mean, I'll throw out, again, I think as the previous panel said, he's one of the court's great defenders of individual rights. Personally, and I'm sure Alex can give me a different take, I think his Levy-Weissman opinion is in the bottom tier of Supreme Court jurisprudence. The notion that, I think, as I forgot if it was Justice Scalia or Justice Thomas said, the notion that, so it was a graduation speech given by a rabbi, and was sort of a non-sectarian speech, and I think Justice Scalia, and was found to violate the Establishment Clause, and I think Justice Scalia made some quip about how the school had established Orthodox Judaism as the official religion of the school. But I think just the analysis, it was sort of the combination of when are people captive audience members versus they think for themselves, and when are they being indoctrinated, and whether the rabbi had been endorsed by the school. I just think it was a hot mess. And so I think, I think there are a lot of areas where he spoke forcefully and clearly, and I think really on some of the First Amendment speech and association things, I think he really helped move the law in a clear and coherent way. But I think on Establishment Clause, at least, I think some of those are problematic.
Okay. I think if Kavanaugh's confirmed, I don't know if he'll get confirmed or not, but if he's confirmed,
That's another, yeah. Fortunately, we don't have to talk about
yeah, we
that
don't
today.
have anybody else specifically to talk about, so I'll talk about Kavanaugh if he's confirmed. But I think he would certainly move the court, or likely move the court to a more judicially conservative position on church-state issues, especially he seems to be a strong proponent of the type of history-based Establishment Clause analysis that I think David was advocating against, in favor, and which I was advocating against. Although, one thing I'd point out is that Justice Kennedy himself, in his opinion, Allegheny, advocated for adoption of a history-based analysis, and then even with Justice Kennedy as generally thought of as a swing vote, the court never actually threw out its existing tests and replaced them with a history test. So, one thing that's important to realize is that, if Kavanaugh's confirmed, I think there's a good likelihood that the swing vote on the court on church-state issues would be Justice Roberts, who's had, in a lot of his jurisprudence, has advocated something of a minimalist approach where he tries to just decide the cases beforehand without making broad pronouncements on what the test should be. So certainly if Kavanaugh replaces Kennedy, the court, I think, would move to the right, but there might not be these grand change in what the governing tests are. I think I certainly disagree with you about whether Lee versus Weiss was wrong to decide it. I think that was a landmark and excellent decision by Justice Kennedy. But on school issues, I think is one area where Justice Kavanaugh would be very likely to move the court to the right. Justice Kavanaugh wrote a brief in the next Supreme Court school prayer case, the Santa Fe case, where the court struck down a school policy of having opening prayers at football games where the prayer givers were students and were selected by a student vote. And Judge Kavanaugh wrote a brief in which he took the other side and supported the policy. And in that brief, he even criticized some of the, or at least implicitly criticized some of the earlier Supreme Court school prayer decisions, such as Engel versus Vitale, which struck down prayer at the beginning of the school day. So who knows what he thinks about school prayer. But one other issue that you mentioned, David, was the offended observer issue. And that's an issue where, at least looking at what Kavanaugh wrote in the lower court case, there might not be any kind of five-justice majority to change the test. Because there was a case called Newdow versus Bush before the D.C. Circuit, where it was a challenge to prayers at presidential inaugurations and also the use of "So Help Me God" in the presidential oath. And a majority of the court there, two of the judges in the panel said the plaintiffs didn't have standing. And Kavanaugh actually disagreed with them. He said the plaintiffs did have standing. And he wrote against them on the merits, but he said they had standing. He seemed to endorse the concept of observer standing, or at least agreed that this was clearly part of the law under Supreme Court precedent. And, certainly, in this observer standing, it's not even at issue in the cert petitions in this Cross case. The Supreme Court has never questioned it. It's decided several cases, again, without discussing the issue, as you pointed out, but it's decided several cases where the plaintiffs were people in the community who encountered the display, and I think it's right that these people should have standing, because one of the main purposes of the Establishment Clause is that the government should not prefer any one religion over another. And the people who are harmed by such a preference are the people who encounter those displays personally.
Yeah, and
All right, David, we'll give you the last word before we move on to questions.
I was actually going to mention that case as one of the rulings I didn't really like of Judge Kavanaugh's at that time. Basically, there was some folks who objected to the "So Help Me God" oath and some prayers at an inauguration. That would seem to me clearly not to have standing at all. Imagine turning on your television and it's the inauguration and they do the oath, "So help me God," and someone says, "Oh, that violates my constitutional rights." That goes back to what I said at the opening. How could that possibly be a personal injury to someone under any constitutional provision? So I think that was, so I think that will matter if he is confirmed as to standing provisions. But I just want to mention a couple of things. So I think Justice Kennedy and the court has moved the Establishment Clause test. The court, especially under Justice Roberts, they don't take leaps and bounds. They don't jump. They do things in a progressive way, a systematic way. The court's clearly moving toward a more historical test, and in fact, the court in Town of Greece has said we have to look at whatever practice it is through a historical lens with a historical understanding. There are 5 justices that talk about coercion. Different types of coercion. There's what's called the hard and the soft coercion. We can talk about that another time. But there are 5 justices that are agreeing that someone, and we certainly agree on that, no one should be coerced to participate in something that's religious. But the historical test and the coercion test, I think you are seeing that's now coming and slowly replacing some of the old tests, and I think that's a good development.
Excellent. Questions for our panelists? Okay, we've got 2 microphones. We'll start here, and then we'll go to the gentleman in the white shirt.
Hi, this question is for Alex. So with regards to the Bladensburg Cross case, we touched upon how you said the cross is exclusively Christian, may be offensive to non-Christian soldiers. Would you apply that same reasoning to the crosses at the Arlington Cemetery Memorial? Specifically, I'm curious to see whether you would say that the Arlington Cemetery crosses also violate the Establishment Clause, or if they're distinguishable from the Bladensburg Cross.
The Arlington crosses are quite distinguishable. The Arlington crosses are in a very large cemetery where there are headstones with numerous different religious symbols that represent numerous different faiths. So if you look at what goes on in Arlington Cemetery as a whole, a reasonable observer wouldn't see those 2 crosses as exhibiting a preference for a particular religion. And also those crosses, they don't dominate the cemetery like the Bladensburg Cross dominates the area where it is erected. And given that those crosses are in Arlington Cemetery itself, which is a National Historic Site, those crosses might have special historic value that the Bladensburg Cross does not have.
So if I could just touch on that 1 second. And I think that's part of the problem. You don't know what a reasonable observer would see. So for example, what size is too big? How many other monuments do you need? Are you secularizing the cross? It's too religious, but if you put on 3 monuments, then it's okay. But if it's 2, it's not. The point of that is whichever way you land on it, it's not a good test. The Establishment Clause can't be on the whim of it's too close to the seat of government, it's too big. If it was 5 feet shorter, it would be okay. We have quotes on the bottom, but you can't see them because they're in the bushes. It's just not a workable test.
Okay. Next.
You all spoke somewhat about the issue of standing and also the interplay between the Establishment Clause and the Religious Liberty Clause, the Religious Freedom Clause, freedom to practice religion. I was wondering if you could speak to what we know about the current justices and any potential justices added to the court, their positions on what the individual right that underlies the Establishment Clause is, or whether they even think there is one.
Yeah, I mean, I think it's been interesting. If you look at the court's jurisprudence going back, the court, I think, and hasn't come out and said this, but it almost treats it as the Establishment Clause as not an individual right, but a structural limitation. Although it tends to reach the merits in a lot of the cases,
the remedy is not to that particular person. So normally when you go to court, you say, I've been injured in this way. The court says, okay, we're going to fix this. Under the Establishment Clause, it's usually a much broader ruling that ends up limiting what the government does. So I think the court has treated it that way anyway. The question is who could bring a case and what's a sufficient injury? I think the limitation of standing to put it more in line with other types of other types of constitutional violations has already been happening over the last 10, 15, 20 years, ever since the Flass case, but we won't get into that. I think Justice Kavanaugh, if he gets through the process unscathed, I'll be interested to see what his ruling is because of the one opinion that Alex talked about. And so that may show a change. I think, though, that he's fairly protective, as is Justice Kennedy, of both free speech and free exercise rights. And so I expect that protection to continue.
Yeah, Judge Kavanaugh did write another opinion in the D.C. Circuit where he interpreted taxpayer standing fairly narrowly.
Right.
So that's an area where if Judge Kavanaugh is confirmed, you might see the Supreme Court further rolling back taxpayer standing, although I'm not sure how much you can really roll it back without completely abolishing it. And at least Justice Kennedy was very clear that he didn't think it should be completely abolished. Whether, if Judge Kavanaugh gets on the court, whether he'd think differently and whether Robertson and Alito would think differently, that's an open question. I mean, it would be very unfortunate if that's the step the court would take, because then there would really be no remedy for a core Establishment Clause prohibition, which is that the government must not fund religious activity. If you don't have taxpayer standing, how do you enforce this core prohibition?
And just to follow up on that, would Justice Thomas view it as an individual right, under his coercion theory, but just in a very narrow subset of cases?
It's a good question. Justice Thomas has pretty straight line historical views and doesn't really move away from that. So I would guess, from everything I've read, a lot of his opinions he kind of reluctantly jumps on, and he puts his position out there and says, but moving on from that. So I would think he would see it more as a structural limitation, but that's just...
Yeah, I would agree. That's what Justice Thomas thinks. I mean, he thinks that the Establishment Clause should not apply to the states, that it was intended to prevent the federal government from interfering with state establishments. So he seems to almost think of it as a states' right. Yeah. And I mean, no other justice has ever agreed with these writings but Justice Thomas, so I don't think that that's going to find its way into majority Supreme Court law any time in the foreseeable future.
Okay, we have another question. Thanks.
Alan Witt, President of the Family Policy Council of West Virginia. About 6 weeks ago, we had another Rowan-type suit filed by the Freedom From Religion Foundation against the City Council of Parkersburg, West Virginia, a town of about 19,000. The facts in the case are pretty similar to Rowan. Obviously, in West Virginia, we sit underneath the purview of the Fourth, which has already ruled in favor of Rowan. But just a couple of simple questions. Since we're talking about the size of crosses and various things, and that seems to matter in some cases, what would rise to the level of violating the Establishment Clause? For example, if various city council members showed up regularly, one chose to wear a hijab, one chose to wear a turban from the Sikh religion. What if a member of the Church of England wore a cross or wore the historic Crusaders cross, the big white one that covered both white and back, their entire torso? What rises, or what would the court deem, or what the panel think rises to the level of establishment just in those personal expressions of religion?
I don't think there would be one, and I think that's one of the problems here with the court not taking the two cases, which I obviously think they should have, is to bring clarification, because what are cities and counties to do when you just say, oh well, and you can have a legislative prayer in these couple of states, but you can't have it here. That doesn't help things because local governments have to know how to act. What is constitutional, what is not. What I would say is that just because someone is a council member of a local town, they don't give up their free exercise rights. They don't give up their religious freedom rights. What they shouldn't do, though, and you said what rises to the level of an Establishment Clause violation, what they shouldn't do is force participation. I don't think an invitation, let us pray, or shall we pray, there's nothing forced there. You're not coerced to. You're not punished if you don't. There's no coercion, which is why we think that's one of the better tests. But they shouldn't be doing that. So if they say, for example, if you don't stand up and pray, we're not going to hear your government business, that would obviously be a problem. But someone wearing whatever it happens to be according to their religious beliefs, I don't think amounts to one. As long as they're not bringing that into their government job and coercing people to participate or not in their religious beliefs.
Yeah, I mean, I don't think we would challenge a city council person's or county commissioner's choice of clothing, whether it's if it's got religious symbolism. It would be different if you have a school teacher who's bearing a proselytizing T-shirt with a large cross with some kind of proselytizing message. That we would take issue with because the students are impressionable, and that would be viewed as an attempt to proselytize a particular religion on students. But when you're talking about politicians, I don't think how they dress would rise to the level of an Establishment Clause violation.
With the crosses on the front and back?
That's really a pretty extreme example. I've never heard of a politician dressing like that, but I mean, if they, I really don't know if we would challenge something like that. I mean, if that might be something that's better left to the.
What about a teacher wearing a
electorate.
turban or something in the school context? Absent that, what about?
I think that the line has to be: is it a personal expression of their faith that's natural to their religion, such as, for example, a necklace with a cross or Star of David, or, if they normally wear, a turban as part of their daily activities, as part of their religion, I don't think that would cross the constitutional line. But if someone's wearing, T-shirts or clothing intentionally in order to proselytize, that would cross the line.
All right, I think we have time for one more question.
Thank you for a fascinating discussion. My question is about the limiting principle. Once we get into the requirement that if you have a Christian symbol, you then need other symbols to kind of cancel out the fact that you have a religious symbol. What is the current limiting principle? So let's say that a small town has some extra funds now and they want to put up a war memorial and use a cross. Right, we don't have this long history to rely on then. Do they need to put 2 religious symbols next to each other to make it constitutional? Do they need 3 religious symbols? How do you go about deciding if a new monument wants to be erected, how to make it constitutional under current jurisprudence and under a future Supreme Court? How would they balance those things?
I think the best thing to do is not include any religious symbols. You can honor all veterans without any controversy, without any favoritism of any religion, if you just have a secular memorial with no religious symbols.
So that's one of the problems. We basically eradicate religion from our country. We exclude churches from the neutral program. Easiest thing to do is get rid of all religion. The problem is that's not what a tolerant society does. The answer, I would say, is that the monument doesn't have to be itself 100 years old. It's consistent with history. It doesn't have to be there all that time. So even something new is still consistent with history and tradition, which is why I think the tests need to move on a little bit.
All right, and you got the last word. Very good. Thanks, everybody. Please join me in thanking our excellent panelists.